Good afternoon, everyone. I'm Cindy Soohoo. I'm the director of the International Women's Human Rights Clinic at CUNY Law School, and formerly was the director of the Bringing Human Rights Home project many years ago. It's so wonderful to be back here at Columbia to celebrate the 15th anniversary of the Bringing Human Rights Home project. I'm just so happy to be here, surrounded by friends and old friends and also new lawyers who are thinking about using human rights in the domestic context. So being here today, I think about how far we've come, and actually I think it's also just getting from that small makeshift conference room in Little Warren to actually Jerome Green, and many of you I think shared that space with me years ago. But when I think about when I started at Columbia in August 2001, which was just a month before 9/11. At the time, Catherine Powell and Louis Henkin had a vision of starting the Bringing Human Rights Home project that would really be a project to support U.S. lawyers to do human rights work in the United States. At the same time, there were activists who were gathering in Mill Valley and later at Howard who would plant the seeds for what would become the U.S. Human Rights Network. And the ACLU was, I think, really just beginning to launch or put together its human rights program. And I think at that time, we didn't really know what was in store. And over the last 15 years, I've really been so inspired by the work of the network and so many others doing human rights work around the country. And I think that during this era, we've really seen constitutional rights shrink. We're kind of unlucky as lawyers to be, I think, practicing in this era. And I think the wonderful thing about human rights is it really expands the conversation, and it allows us to have the conversation and work for the world that we want to see. And today, I think, we've continued to push the U.S. to live up to its human rights obligations post 9/11. It was really about, a lot of it at the beginning was about the war on terror and thinking about the U.S. recognizing that it can't commit torture in the context of the war on terror. But today also, we're talking about torture and cruel and human degrading treatments in police, in the actions of police. We're talking about it in jails and prisons. And we're also talking about issues that we all care about and I think formerly didn't have enough space for, in terms of the human right to water and the human right to health and the human right to housing. And so I think the network has really played an invaluable role in shifting that conversation and creating new spaces for advocacy. And so today I'm thrilled to be moderating this panel, surrounded by folks who have really been on the vanguard of thinking about human rights in the United States. So I'm going to do a quick introduction, and I feel like I've worked with you all for so long, but your titles keep changing as you keep getting all these promotions. But on my far left is Ejim Dike, who's the director of the U.S. Human Rights Network. Jamil Dakwar, who's the director of the ACLU's Human Rights Program. Eric Tars, who's the senior staff attorney at the National Center for Law Center for Homelessness and Poverty, and then Reena Shah is the director of the Human Rights Program at Maryland Legal Aid, and Melissa Hooper is the director of the International Law Scholarship Project, or the Pillar Project, at Human Rights First. So I'm just going to start just asking everyone to just talk about one or two examples of how you've really used human rights strategies to move an issue forward. And anyone can start. Oh, everyone is so shy today. Eric?
All right. So I'm excited to be here at the 15th anniversary event of the Bringing Human Rights Home Network, and to be able to say today what I couldn't have said even 5 years ago, let alone 10 or 15, which is that we have a concrete example of federal policy change directly as a result of international human rights advocacy. And this has been something that I have literally been working my entire professional post-law school career on. I came to the Law Center 9 years ago now as their first human rights staff attorney to help achieve their organizational mission to end and prevent homelessness in America, which we realized we could not do unless we come to the place where we accept housing as a basic human right in our country. But I also came there not from the housing rights perspective, but from the human rights background, with a personal mission to create this concrete example of human rights advocacy that we could be sharing and modeling to others to help advance human rights across the board. And so we sketched out what we knew at the time. In litigation, the cases where the Supreme Court has looked at human rights has often been those where the record at the international level is just so clear and consistent. You know, the juvenile death penalty, case after case at the Inter-American Commission, the treaties, the treaty reviews, all of that, pushing to the point where Roper could cite, even if not bindingly, but at least persuasively, that that this should be something that should be an interpretive guidance to the court. And we also knew that our ultimate goal, the right to housing, is part of the economic and social rights sphere, whereas we are more comfortable in the U.S. talking about civil and political rights. So we looked at what could we do, and we saw the criminalization of homelessness as an issue that sits at the crux of civil and political rights and economic, social, and cultural rights. People on the streets aren't being criminalized. You know, they wouldn't be criminalized if they had a home, and if we can get to the place where at least we can say people shouldn't be criminalized for simply having to undertake basic life activities outside because they don't have a home, maybe then we can push further to the place where there's a governmental obligation to provide that home as well. So taking that, we used every relevant UN lever that we could. We started with special rapporteurs. We met with them. We brought them to the US. We did country visits. We wrote letters and complaints, and we built the record. That record then started being, was our basis when we went to the treaty bodies to say, look, you aren't going out on a limb to say that criminalization of homelessness might be cruel, inhuman, and degrading treatment. This is something that people are already talking about this way, and then we were able to move it forward. And every treaty review that happened in 2014, plus the UPR in 2015, cited to criminalization of homelessness as cruel, inhuman, and degrading treatment as something. And we got very specific recommendations from each of the treaty bodies that the U.S. should create federal funding incentives to end and prevent criminalization, and that the other federal enforcement agencies should be taking increasing action. And importantly, we used it not just the international side of the process, the actual treaty reviews themselves, but we worked within the government to use the treaty reviews as a hook to get meetings with agencies who, you know, have to deal with criminalization, but who none of whom are actually concentrating on it full time. And so we said, you've got a question coming from the Human Rights Committee on criminalization of homelessness. You have to respond to it. Here's how we would want you to respond, both in writing but also substantively. These are the responses we would want to see. And so we were very focused in those meetings on what our demands were, our federal funding incentives, and increased enforcement actions. And when we got the international bodies to echo and make recommendations on those specific points, we came back again and again and again, as Carrie just said, repetition, squeaky wheel, getting the grease. And this summer, we achieved success. The Department of Justice intervened in our case in Boise on an anti-criminalization, anti-camping, against an anti-camping measure there. And not only did they put in a brief in our case, but they put out a press release about it. It got huge press coverage. We got an editorial in the Washington Post. We got NPR. We got AP News all across the country. So they did it, and they did it with a purpose to make it big. And then just a few weeks ago, HUD put out their new federal funding questionnaire for homeless continuums of care with a question on the criminalization of homelessness, asking what communities are doing to end and prevent it. And so we've got now the Department of Justice enforcement through a statement of interest brief, and we've got HUD using the power of the purse to discourage local communities from implementing criminalization policies. And I would note that the Department of Justice has acknowledged that the human rights context was important in their decision to put in that statement of interest brief. And HUD on their webpage dealing with criminalization has the words, criminalization violates our human rights obligations on it. So there is zero doubt, you know, with many federal advocacy things, there's so many different parts of the picture that get you to the end result. But there's no doubt that this advocacy has resulted in these measures. And as a result of them, at least one community has rescinded and amended its criminalization ordinance, and several other communities have tabled criminalization or proposed new criminalization ordinances and stopped going down that road. So there are homeless people on the streets of America tonight who are safer because of the work that we did at the international level, and that's our end goal. So that's, yeah.
Thanks, Eric. I'm actually reminded, your boss, Maria Foscarini, often talks about human rights lawyers being do-it-yourself lawyers. Have you guys heard her say that? And just this idea of working to create this recognition of criminalization of homelessness as a human rights issue, and then working so that it's firmly established and bringing it back, I think that's a great example.
And all of this is discussed in further depth in our report on our website, Human Rights to Human Reality. And so we kind of took the lessons learned from the process, and you can see it all there.
Maybe, you know what, Jamil, do you want to talk a little bit about the other work at the international level? Or maybe you want to talk about something else?
Well, is that working?
Yeah.
So I really wanted to add that ACLU as a multi-issue organization, one of the challenges for us were where do you start? Where do you start using human rights? In which area of the ACLU? What are the capacity that you have, the understanding of the framework, its implementation? It's not something that you can really turn it in overnight. So from the beginning, we have to be realistic about what we want to achieve. And so we picked like 4 main areas, or 4 or 5 main areas, starting with women's rights, racial justice, immigrants' rights, national security, and criminal justice reform. Basically capturing a lot of the work that the ACLU is doing and using the framework in that area. And you've heard a lot from Carrie today about the work in the area of violence against women. It's, in fact, that's one of the first cases that the Human Rights Program worked very closely with Women's Rights Project and other partners to take that case. Lenora Lapidus is here, has been really instrumental in also making the ACLU work on women's rights, incorporate human rights framework, to the extent that there was a roundtable at the Justice Department recently looking at human rights framework and ways to address violence against women or gender violence as a result. So that's, I think, a beginning from 2004, 2005 to now. It's been really great. But really in other areas we had to think about incremental changes. So while there's a lot of policy work that's been done in the last 10 years, or certainly the last 7, 8 years, but there's a lot of areas where we kind of connected the different violations that happen and used the human rights framework as a way to tell the story in a much more comprehensive way, to better connect with communities that are working on issues. Racial profiling would be one of those areas. People were not talking about racial profiling as affecting people of color more broadly in this country. They were talking about racial profiling against African Americans and maybe Latinos. They were not really thinking about racial profiling as immigrants and what happened particularly at the southwest border of the United States. They were not thinking about racial profiling post 9/11 in those terms. So we were really able to kind of connect those dots and talk about racial profiling as a human rights violation with using documentation, using international advocacy, using policy in DC. Our office, Washington Legislative Office, put together a panel with a member of Congress to talk about the 3 dimensions of racial profiling. And then moving into other areas like criminal justice reform or criminal justice violations, where the U.S. is certainly out of step with the rest of the world, where we feel that this is an area where we could do much more progress in using international standards and norms and advocacy from juvenile life without parole, partnering with Columbia Human Rights Institute, the Michigan affiliate, and Deb LaBelle. We've done a lot of great work not only in the international arena, but also in domestic litigation, and continuing to work with coalitions that are been created to address specifically juvenile life without parole, and moving on to other areas where I think that's really the most exciting kind of form of how to utilize the human rights framework is the area of solitary confinement. I think 4 or 5 years ago, few people really understood the magnitude of the problem in the United States. And it really was the work of a lot of organizations around the country coming together with a strong coalition, a strong campaign, and with a framing of the issue as also as a human rights violation. Partnering closely with the United Nations Special Rapporteur on Torture, Juan Mendez, who in 2011 issued a global study on solitary confinement, which was embraced, adopted by the domestic human rights movement as another major tool to address solitary confinement as a human rights problem, and work on the state level on reforming that, to the point that you see justices at the Supreme Court talk about solitary confinement as a major problem. So there's a lot of that's been going on, but I don't want to neglect other parts of the organization. Of course, we in the Human Rights Program, we're a small team. We really depend a lot on our colleagues in the National Legal Department, but also in the affiliate level. Some of the affiliates, by the way, were more excited about use of human rights than us. Certainly areas like homelessness, because of the way that they are more connected to this issue at the state and local level, issues of poverty, issues of policing, where Puerto Rico, for example, using human rights documentation, we were able to bring media attention, national media attention to the widespread abuse by police in Puerto Rico and lead to reforms, working closely with the affiliate and partners and the Justice Department. And finally, the area of workers' rights and trafficking, labor trafficking. It's been really a great work that was done by my colleague Chandra Bhatnagar, who's now he's now with the EEOC, but really kind of thinking about ways to tackle the issue of workers' rights and frame the issue of undocumented workers, workers' rights in general, those classes of workers who are left out of protections by national standards and laws, kind of enabled us to talk about all these issues and provide answers, solutions, policy solutions, but at the same time keep the conversation moving and always think creatively about how the human rights framework could help communities that we work with to advance the situation so that they will be able to achieve much more than what the domestic system provides as far as civil rights and constitutional framework.
Thanks, Jamil. Wow, but you've said so many things, and there's so many things actually I think so many people here can actually pick up on. I think there's an issue of working in coalition, working with communities, which maybe Ejim wants to address. I think there's also interesting things about how do you move an organization along, a national organization like the ACLU, and it'd be interesting to think about how you do it also at the legal services, and also issues about changing the frame and issues on solitary confinement, and I know that human rights first. So who wants to jump in?
People hear me? Can you hear me now? Yeah. Okay. Thank you, Cindy, and thank you, Teresa, for inviting me here today. So let's see. I guess I'll jump in when we talk about coalition and working with community. But I wanted to start because one of the students earlier, I think she was a student, asked a very interesting question to Carrie. And that had to do with the role of culture and culture shift and the effectiveness of legislation. In her question, she was asking about reducing rape or incidences of rape in India. And in thinking through what would be one example of a success that we've had, I couldn't really come up with anything that was really concrete because let's face it, we're not getting concrete wins every day in the human rights movement. But we do have some really good examples, and I commend Eric, ACLU, everyone here for all the work you've been doing. What I would say is that the most concrete win that I've seen in the human rights movement is the almost complete shift in the landscape of who identifies as being part of the human rights movement. So when I started doing this work 13 years ago, there were a handful, and literally a handful of organizations that identified as doing human rights work. And they were big institutional players, and they're still part of the human rights movement. But guess what? Now, The human rights movement is dominated by grassroots groups around the country, people who are directly impacted by issues, who identify as being the human rights movement. And for that reason, people now identify and recognize that we have a human rights movement in the United States. And I think that that is necessary for any win that we're going to get. Eric referenced a special rapporteur coming. That visit would not have been successful if not for the work they did, along with Nesri, to bring all these grassroots groups from around the country and get them involved, people working on the ground on the issue of housing and on homelessness, get them involved in that process. That's how we create culture change and shift, and that's how we get things done. And we've seen that evidence at the network. We've seen that evidence in our membership, like people who are the most vocal now are mostly grassroots groups. We've seen that evidence in people who go to the international reviews. I was doing the numbers earlier today. We have, of the delegations that have gone to the review on the ICCPR, the Covenant on Civil and Political Rights, SIR, the Convention on Elimination of Racial Discrimination, CAT, Convention Against Torture, and the Universal Periodic Review, about a third of them are grassroots groups. And that's significant because if you think about it, Geneva is very expensive. So for grassroots groups, directly impacted people to be able, in some cases supported by the network, in many cases crowdfund to get themselves over to Geneva to protest, that's a big deal to have a third of people being that. And for the Convention on the Elimination of Racial Discrimination, about half, almost half of the groups there were grassroots groups. And there's a reason why groups working on racial justice predominantly are the ones who are looking outside the United States, the confines of our law, to international human rights law to seek justice because they see over and over again the limits of our laws. So I think that for us, that's been the clear, I don't know if you call it a win, but it's a clear step towards a win. Just 2 weeks ago, Sabrina Fulton, who went with us, that's Trayvon Martin's mother, who went with us to Geneva in August of 2014, was talking at the 20th anniversary of the Million Man March and talked about it as a human rights issue. Alicia Garza, who was one of the people who coined the phrase Black Lives Matter and is part of one of the leaders of the movement for Black Lives, she's also put out a petition recently talking about the issue of racial justice as a human rights issue. We have members who are petitioning the United Nations directly asking for intervention for blue helmets, things that we ask for in countries that are not, I guess, in the global north, to come into the United States and intervene on the issue of excessive use of force by police. So I think all of those, that's a necessary shift in our culture, in the way we do advocacy, if we are going to get any advocacy wins. And so that's my example of a concrete win.
Thanks. All right, we're going to turn it back over here. Reena, do you want to start?
So following up on what Ejim was talking about, for legal aid, I think we are probably, of the folks up here, the newest player in this, and we are a legal services organization. We're state-based, so we don't work at the national level, and you know, we provide direct legal services, and the model for that really is individual representation. The history of legal services is that it was created really as a poverty alleviation sort of mechanism, right? How can lawyers be agents for social change and social justice? And you know, through the history, in the 80s, when the Reagan administration came in, you know, essentially in California, there was a great history with CRLA, which is the California Rural Legal Assistance. They were suing the government like crazy, right? That's what legal services lawyers were really good at doing, is really good at suing the government and getting changes for people on the ground. And so it didn't really sit well with the government so much. And so, and so what they've done is restricted our funding. So if we get any kind of federal funding, right, from the Legal Services Corporation, which we do, our organization does, and most organizations do, who do legal services, then even if you get a penny, right, then all of your funding is restricted. And that means the restrictions are you can't do class actions, can't do impact, can't do organizing, right? So you can't get a group of people together who all have the same issue and say, we're going to organize together, we're going to go and change the law or get some relief. Can't do that. Can't initiate legislative advocacy, right? So there's constraints on what we can do and the strategies that we can employ that other folks don't have those constraints. So the way that we've tried to do it, and you know, I got into the position in 2012, so we were about 3 years in. We have to do it in advocacy, so suing is still totally okay for legal services people to do, and so we're trying to incorporate it into our arguments. But as was mentioned by Carrie before, and we can't necessarily say it all the time, right? Because judges don't really know what you're talking about. And we're really in the phase of raising awareness. I mean, literally in the first year, it was really about even raising awareness among staff. Because when you talked about human rights law, I had worked overseas a lot before sort of getting into law school. And if you were at all talking about poverty or poverty alleviation, legal strategies or campaigns or anything, human rights was the language. That was what you used. Everyone understood it. Everyone knew about it. And so that's the starkest place, you know, when you're working in an organization that's just starting this, is we really had to be like International Law 101. What is a treaty? Like, what are obligations? Why is it enforceable or not enforceable? What are the complications? You know, so you really had to start at that level. And still, I would say, I mean, now I think we're at the level where everyone in legal aid, Maryland legal aid, must know, you know, what these human rights norms are and how they can apply. But really, that's where we are. And then when you go outside the organization, judges and decision makers, et cetera, it's really about raising the awareness, trying to make small incremental changes, as you were saying. So a concrete example for, you know, we're always looking for concrete examples. Just the shift in people's minds about housing, for example. Housing is a big issue area for us. So we're very used to hearing about affordable housing. We're very used to hearing about maybe habitable housing. You know, housing should be habitable, you should be able to live, et cetera. But we're not really used to hearing about adequate housing, right? The international term is sort of the adequacy of housing, and it has 7 or 8 components to it. And so really, you know, informing our staff and our advocates about like what that means. And so when you're talking about like, if you don't have transportation hubs near your housing, that's not adequate, that's important. Because essentially what our practice was, you take people from bad housing here and you put them from bad housing there, right? There's not a lot of good solutions. Thinking about small solution changes. So when I entered my practice as a housing attorney, one thing that we used to do routinely, just routinely, was, okay, so someone gets a notice that they have to vacate because their young child, you know, teenage child, most likely African American, because I worked in Baltimore City, so that was the general population that we served. They had probably some mental health issue, a lot of my clients, and there was some criminal record that was created because of, you know, some interaction between their mental health issue, the way policing is done, et cetera. And our solution to preserve the family's housing in general was, okay, we're gonna kick that person out. We'll make an MOU with the housing authority to say that person will leave, they'll go stay with some relative, we'll preserve the family's housing, right? When you look at that from a human rights lens, you have to change that solution, right? So you really have to think about, that is really not a good solution for anyone. You're preserving the family's housing, but you're disconnecting the family. And then what kind of supports does that person have that to get them back into society, right? So it's these small things. So I would say there's been 3 critical things that we've been able to do that I think have planted the seeds. We are by no means anywhere to, you know, I will discuss a case that we got a good result on. But first is understanding the client. One thing that we've really focused on is understanding our clients and what human rights allows us to do because of the intersectionality of the issues that our clients face is really looking at them as a whole. A lot of times lawyers, when they interview their clients, they're very issue specific. Do you have a housing issue? Do you have an unemployment issue? And you try to put them in these categories right away so you can say, okay, you go to this type of attorney, you go to this type of attorney, we're going to resolve your problem. Our clients are extremely complex. They come with extremely complex issues, and so to understand the interrelatedness of their issues is very critical. That's something that we've really worked on, and human rights has helped us with. Another thing, of course, the new laws, the new toolkit, understanding these things better, having a broader perspective, having new forums, having different approaches, and having different solutions. So that's really what our focus has been, is really analyzing what we're doing, trying to use these different ways to achieve something better for a client than they would with just local law. And finally, another concrete thing, of course, I'm based out of Baltimore. So the Baltimore Uprising was huge, kind of an earth-shattering moment for all of us who work in Baltimore. And I think what, as far as working in organizations and moving organizations towards something, when you're doing individual representation and you're really locked from doing a lot of systemic work, but you want to do that, that's the level of change you want to have. One thing we were able to do post-uprising that really came out of the Human Rights Project was think about race equity. Lawyering on an individual basis, you still try to get those solutions that are just good for that particular client without really thinking about the structural racism aspects of everything that's going on. And the uprising just forced everyone to really think through that and think about how we can incorporate both race equity frames and human rights frames together into lawyering, which is really challenging. I mean, really challenging. You can do it sort of on an advocacy way, but when you're trying to bring it into your arguments, so that has been a lot of the work. And something concrete may seem small, but we're the largest legal services in Maryland. We have a budget of over $26 million. We are by far the biggest player, but we were not doing anything on, for example, expungements. Right? So when you're thinking of race equity, something that the project was able to move the organization on was, where is the intersectionality between criminal and civil law? What do we need to do? Because there are many collateral consequences of criminal records, and those collateral consequences we see in housing and administrative and everything that we do, but if we're not working on the basic, employment, which is a big thing, in doing expungements, then we're really not resolving a lot of those issues. So something the project was able to do was really move the organization to take up expungements in direct response to what happened in Baltimore. Thanks.
Thanks, Reena. All right. Melissa?
Great. So actually, it's really inspiring to hear of everyone here. I am the newest, actually, because my project is a year old. Okay. And so, yeah, I know. And so we've just been starting out and trying to find our place in terms of doing litigation work and focusing on something that Reena just mentioned, educating judges, and the fact that judges often don't know what to do with something that's coming at them in an international human rights law framework when it concerns the U.S. And I think that part of what informs our work is a philosophy that comes from, that I also, I think personally, is very persuasive in that I have worked a lot overseas. That was much of my legal career. And coming back, was invited to work on this project to try to educate the U.S., to take a perspective, an international human rights law perspective, and focus that on itself. So to take that perspective that it aims at other countries when it says you need to be living up to these ideals, you need to be meeting these standards, and to examine the way it's meeting, the U.S. is meeting these standards, which is to say we're often not meeting them, and in many areas we're falling down, and need to be reminded. And so we're trying to do that through the court system and through educating judges through amicus briefs. And a couple of successes, or a couple of areas where we have found in our first year as we're starting out, where we find some acceptance and judges willing to consider this. Number one, we've learned that where there are gaps in US law, using international human rights law can work. If a judge doesn't have another framework to look at, we can bring in, we can borrow and we can get some success there. We had a Foreign Sovereign Immunities Act case that related to a forced disappearance, and the DC Circuit Court said, well, we don't really have a test for determining when there was a forced disappearance. That doesn't happen in the US very often. But our amicus brief offered a framework from the Inter-American Court and from the European Court, and the DC Circuit Court said, yes, this is a framework, we can use it, we can borrow that, and that will work for us in the US. Another strategy that has been helpful for us is using unexpected voices. And this is something that Human Rights First as a whole really tries to concentrate on. And we have a working relationship with retired military leaders who take a strong stance against torture. And that has been very helpful for us when working on cases related to alien tort statute cases against military contractors for participation in torture, for example, or most recently, we've been working on some Guantanamo cases related to when hostilities begin and end, and whether whether detainees might need to be released at some point in the near future. And so having military leaders discussing these issues and torture issues is very persuasive. And most recently, the military leaders have also become interested in the issue of trafficking, and so we've been working with them on a trafficking case that again is dealing with military contractors, and so their voice is very persuasive there. And then a third strategy I wanted to point out is that I kind of, in my mind, think of it as the shield to sword strategy. And I have, there's a really excellent example of this that is not from my office, but we witnessed it. And so I want to just call out the people that participated in it. And the shield to sword strategy I think of is when the government says, well, we don't need to adopt this international human rights standard because we have our own and it's just as good. And it incorporates that international human rights law standard. You can turn that on its head and say, well, then it must mean that all of these requirements of the international standard fit within our framework. So an example of that is in Ashker v. Brown, a case out in California, a solitary confinement case that recently settled. Center for Constitutional Rights was leading it, but a number of other organizations were involved and very active. But what they did was they worked with Juan Mendez, Special Rapporteur on Torture, he was an expert in the case, not the Special Rapporteur, but he essentially described the ways in which the Eighth Amendment, if it incorporates the Convention Against Torture, must require that all of these tenets be met and must require that solitary confinement as torture is not used by the United States. So I wanted to raise that as a method that we could all use and be thinking about it. In becoming more successful in bringing human rights into our individual cases.
Thanks, Melissa. It's really interesting to hear about sort of some of the strategies we've been thinking about for a long time in the network, and also the newer strategies that people have developed, and also just the more nuanced way that people are thinking about their advocacy. I wanted to ask you folks also to talk about a challenge. I think, when we started the network, we had ideas about what we were going to do, and I think we encountered a lot of challenges, and people maybe changed their approach. So I wanted to ask about maybe a challenge or lessons learned. And maybe, Eric, for instance, I know that one thing that you've really been trying to do is really to change government and the way that government understands its work rather than suing government, sort of hoping that various agencies really take a human rights approach to their work. So could you talk a little bit about how you change a massive culture like that? And I think Carrie was talking about that earlier as well.
Sure. And I would say, just to quickly build on Melissa's point in terms of thinking differently about what success looks like, for me, when I came in, I said, I'm building these standards at the international level. I want to get recognition of criminalization of homelessness as cruel, inhuman, degrading treatment because it's similar to our Eighth Amendment standard, and I want to use it directly in litigation. But what we got was the Department of Justice to intervene in our case and set a national standard, above and beyond, that although it didn't cite to human rights, we asked them to, but they didn't take that step, but that's okay because it made a huge impact anyway. And so maybe that's another, nuance to thinking about human rights lawyering strategy and human rights litigation strategy is you don't need to get human rights referenced in the brief itself if you can get the Department of Justice to come in and intervene in your case. And the way that, but we came to that by having those meetings that I was talking about. And so to your question, I think the way we've shifted the culture within the agencies that we work with is, as Carrie was saying before, squeaking the wheel. We used every opportunity we could to meet with these people. We were aided by the growth of the national domestic human rights movement and the work of the Bringing Human Rights Home campaign and the Human Rights at Home campaign, the U.S. Human Rights Network, to coordinate groups and get the treaty reviews and other processes to move outside of just the State Department and into the domestic agencies and start having meetings, collective consultations before the treaty reviews. But what was critical for us was not stopping with those government-run consultations, but using other opportunities. So every time we held a training or a conference, we would invite government officials to sit on our panels, in part to share their expertise, but in part it was a very deliberate effort to force them to sit for 90 minutes and have to hear about our issues as human rights issues. And it worked. Every time we had a special rapporteur visit, even if they weren't here on an official mission visit, they were here to talk about coming to the General Assembly to do their annual report. We would bring them down to DC, have some meetings with these same officials from Justice, from the U.S. Interagency Council on Homelessness, from HUD, to talk about our issues, criminalization of homelessness, as a human rights issue. And we built familiarity with them. And in DC, so much of what goes on, it's not what you know, it's who you know. It's building those relationships. And importantly, every time we had a victory or success, including things that the government itself was doing, we let the left hand know what the right hand was doing, and we created our own echo chamber. And I have a list of government officials who, when this DOJ brief came out, when HUD did its thing, when the U.S. Interagency Council on Homelessness put out a blog saying all of these things are part of our human rights implementation, I send it back to them and I reinforce that, when you do bad things, yes, we will call you out on it, but when you do good things, we got the special rapporteurs to, put out a press release lauding the U.S. government for calling criminalization of homelessness a violation of our human rights obligations. So it's creating that positive echo chamber and just, keeping on squeaking the wheel, I guess.
I want to ask Reena a question, and then I think Jamil also has another challenge. I'm not sure whether Ejim does, but I think it's wonderful to hear about the work doing education at the national level. I feel like one challenge we've had as a network, going from the very beginning when we used to have these meetings with Bob Harris from the State Department, and he would say he's trying to get information from the states, and he would send them a letter saying, we're the State Department, we need information, and he would get a call back saying which state. Like states didn't even know what the State Department was. And many of you have been in the room with me when he said this joke many times, and it stopped being funny at a certain point. But I think there is this issue, and many of us actually work on we have a federalist country, and many of us work on issues that are really in the control of the states, including policing issues, criminalization issues. And Reena, I'm wondering whether you can address kind of trying to deal with things that are sort of left at the state level.
I mean, again, I think what I said before, I think the awareness raising is just the key, I think, challenge and opportunity. With the, what was I going to say? I totally forgot what I was going to say. So I think awareness raising is one. Oh, the other thing I was going to say, Maryland does have sort of human rights commissions in certain counties, but the understanding of what human rights is extremely limited. So human rights commissions means non-discrimination, and that's it. It does not mean social and economic rights. It doesn't mean this broader sort of understanding. So one challenge at that level, even when people have human rights in their names and you think they're going to be natural partners and we're going to be able to work together, is the realization that the understanding, we're not all speaking the same language or even have the same understanding when we say human rights. You know, I recently was meeting with the Maryland Commission on civil rights, but they have some portion of their name or network that has human rights in it. So I was like, yes, this is going to be the perfect partner. And as we got to talking, it was sort of like, well, what is human rights? And what is human relations? And what is civil rights? Like, what's the difference? So it's really there. I mean, that's where we are. And then, you know, in doing sort of race equity and human rights work together, there's a race equity world, and then there's a human rights world. And it's kind of like, you know, sometimes the people who use the CERD and use all the human rights instruments, it's still kind of, it's the language. It's like making that connection to say, like, when we say this, this is what we mean. So, you know, it was really odd for me to be engaging with people who are like, well, if you're talking about human rights, then you must not be for Black Lives Matter. This is true. And this is a reality on the ground, right? So to understand that human rights can stand for, because you're standing for everyone, all lives, right? How that can, but you're, so, you know, these are like on the ground level in the past few months, I've just had a lot of revelations about, it's the law is up here, and that's fine, and you can engage with it, and we do different things to engage the judges. But really, even at the community level, when we're trying to engage people, it's just language. You have to have clarity of language about what you even mean when you say human rights.
Jamil?
Yeah, I want to build on this comment. I think that certainly this is one of the big challenges is awareness raising, education. I think, as a lot of people said, and I agree with that, you know, communities, affected communities have a much stronger understanding of what that means. And we don't, you know, have to kind of, you know, there's an education part on as to process and mechanisms and how to empower and translate those into action, but in terms of using the system. But it really, the understanding is there. I think when the big challenge is when you're talking to people who are policymakers and legislatures and judges and lawyers and even media in this country. The media doesn't want to talk about human rights in the United States. Very reluctant to do that. I can share with you an example of a very prominent human rights scholar with international recognition. Just days or week before the UPR, United States UPR in Geneva, that was recent, tried to get an op-ed in the New York Times. And there was a back and forth, and ultimately got rejected. Now, if you can imagine if that same scholar sent that op-ed, draft op-ed about, you know, Cuba or some other countries in where the United States is very strong about, you know, bashing that country for its poor human rights record, I bet you it will be there and will be promoted by the New York Times. So I think there's that part that we should really pay attention to. The other thing that I think is really concerning, it's a really big challenge for us, is how the conversation about human rights, particularly around the circles of you know, officials and policymakers, is that it's not really a law, it's really a policy. Talk to us about human rights law as a matter of a policy, not as a matter of law. And I think that is really a dangerous premise, because when you talk about policy, you know, it could change with administration. You know, today we have friendly administration, tomorrow, who knows? We know the experience of the post 9/11 world and what happened with when you turn a law into, distort the law definitions and so forth. That, I think, one of some of the things that we have to really push back against. Yes, we would talk about policy, but we should not, you know, neglect the importance of the law, importance of human rights law in that. I just want to just mention one last thing that I think And here, for example, the Torture Prevention, Victim Protection Act, as a recent law that was adopted in 1991, partly, by the way, some people don't know that, partly in order to implement the Convention Against Torture, which the United States had signed during the Reagan administration and ratified it. The ratification process took a few years, and only in 1994 the United States or the Clinton administration signed off on that. But it was because there were a number of pieces of legislation that had to be moved forward, including the Torture Victims Protection Act, which provides a legal remedy for victims of torture and other gross violations of human rights like extrajudicial killings to move forward. We can't even dream about those sort of things, of like a Human Rights Act, or at all levels. And I think we shouldn't. And I think with the movement that we're seeing now, with the Black Lives Matter, we certainly saw the movement in Geneva with We Charge Genocide, and the way that we talk about these issues, and they bring the media and the policy people and the law legislature to understand the importance of that. A lot of people who are not in this room, or maybe they're not watching, but there are a lot of really big victories because of that. I mean, what happened in Chicago with creating this fund to compensate victims of the Chicago Police Department. The lawyer was with us in Geneva in 2006. Mm-hmm. In fact, one of her clients, Joey Mogul, one of her clients testified at a side event in 2006 with on a video testimony that was provided. It was the network, the ACLU, and other organizations who were there. We said, we can't talk about human rights without hearing from the people who are affected by human rights violations. And we had someone from Katrina, from the Gulf Coast, who came from Louisiana to talk about the displacement of African Americans in particular after Katrina. We had a juvenile who was sentenced after unfair trial and use of torture by the Burge Police Department in Chicago. We had Jessica Gonzalez with us at the time, Lenihan today. And we had a torture victim who was a victim of the CIA torture program, who also testified about that. And you can think about the power of these people who weren't talking about these issues. And I think every time, and the network set the standard, every time we do this thing, we can't just have the lawyers talk about these things. They gotta have to do the advocates, the lawyers, but more importantly, the people who are affected. Absolutely. And people who are driving this. So I think those are just kind of some of the challenges, but opportunities, and just looking forward at how we do a better job with that.
Do you want to respond to or add to this line? And then I'm going to go in a different direction. So.
Okay, you're here. Let's see. So there are a couple other examples, too, that I feel like I should mention. Also having people who were formerly undocumented in Geneva forced the treaty bodies to talk about issues that they may not have heard about, like Operation Streamline. In other words, criminalizing crossing the border more than once. And shoot, there was another example I had. Oh, the other example was having Stephanie Schroeder, who was a survivor of sexual violence in the military, go to Geneva and speak there. She actually got the first apology and recognition that she'd ever gotten from the U.S. government because she was there in person. So yes, it's very important to have people who are directly impacted leading the movement. I have a challenge that I want to raise here because I think we have a room full of human rights lawyers, or would-be human rights lawyers, and I think it's an important one, and it speaks to some of the things we've talked about. You know, there's one version of Dr. King's famous quote on how we need to move from a civil rights era to a human rights era that that is followed by a statement that because human rights is not governed by the confines of the Constitution or something like that, but is governed by humanitarian concern. And I feel like, as one of the things I've come across, I'm not a lawyer, but I've worked with lawyers, love lawyers, because it is true that some of the most creative people I've met, including Carrie, I should give you a shout out, is one of the are the most creative thinkers and trying to figure out how we push the boundaries so that we can reach that ultimate goal. But one of the challenges that I think human rights lawyers face, period, is that in some ways your job is confined by the Constitution, by existing law. Yet human rights is asking you and demanding that you look beyond that. A challenge is to find yourself retreating back into the confines and never challenging it, and saying things often like, oh, well, that's never going to pass. That's unrealistic. Let's be realistic here. You know, they're going to laugh at us. And being willing to be laughed at. Because if we don't, yes, it's true that we need to be, or I don't know if we need to be, but it's important that we be incrementalists sometimes. But, and you also mentioned this, Carrie, we need to also define that ultimate goal. And we should always be thinking 2-3 steps ahead. So I've talked to many lawyers who I know mean well, who want to change the world just as much as I do, but who are afraid to mention things. And in fact, before this, the movement for Black Lives really took the stage, I know many human rights lawyers who wouldn't want to talk about Black torture in the same way as they talked about torture. I have had these conversations, and these are our friends. So I think it's important that we challenge ourselves constantly and that we try to confront the fears that we might have. And let me say, it's not just lawyers, okay? It's all of us who are trying to move forward. But I find it particularly present when you're confronted by the constraints of the law. So I want to put that out there as a challenge to all of us. An opportunity, and I neglected to mention this earlier, but tomorrow, actually today and tomorrow, the Inter-American Commission on Human Rights is having a series of hearings, including on excessive use of force, and tomorrow one on the human right to water. And we have about 20 groups from around the country who are convening in Washington, D.C. to talk about this issue. About half of them are people directly impacted by the issue, from Detroit to Baltimore to New Mexico to California to Georgia. I mean, people are moving past the law. People have realized that our domestic remedies are insufficient, and they're moving past it. So I feel like that we as the human rights community should be the ones leading that charge.
Thanks. Thank you for reminding us that we need to look beyond, I think Monique Hard said, the shackles of U.S. law, right, and have a broader vision that really incorporates human rights. I wanted to sort of shift a little bit and just address another, I think, enduring challenge that we have in the United States, which is the issue of U.S. exceptionalism. And probably like 2 or 3 weeks ago, Somalia actually ratified the Convention on the Rights of the Child, which I don't know if people know, but it was just the U.S. and Somalia who had not ratified the treaty. So now it's only the United States. And I think this is an issue we need to confront. And I don't know whether Melissa has thoughts about how we deal with this issue.
Well, good old-fashioned embarrassment, I think, is quite helpful sometimes for the U.S. It's not always helpful, and I think that we have to decide when we're going to embarrass and when we're going to partner in order to get something done. I can't say that I have a specific strategy, but I think for us that we've been looking at how this fact might be useful in examining immigration detention from an international human rights law perspective, because the bedrock standard of the CRC is the best interest of the child, which is also the bedrock standard of a lot of U.S. policy around children and how we should be taking care of children. So we're looking at how we might be able to work with medical pediatric policy leaders in order to call out the U.S. specifically for its family detention policies and then in doing so try to push the U.S. or to examine its policies in light of the CRC, even though it's going to say, well, that doesn't apply to us, but the bedrock standard does. So that's one thing that we've been looking at.
Yeah. One thing about that, about the U.S. exceptionalism and the CRC. You know, when we started to look at treaty ratification, particularly with the Obama administration in 2008, 2009, one of the things that the administration was very excited about was pushing the Disability Rights Convention to get the consent and approval of the Senate, and it went twice and it did not get the approval. And everybody knows that this is not this is really very, very difficult, not just because you have to get a 2/3 of the vote in the Senate, but it's really, the problem is more fundamental. The problem is that there's a very organized movement against, those values that we are talking about, human rights and the concept of what is the role of international framework, international legal framework, and how that the interplay with the U.S. But I think that, there's also this risk. I mean, there's a nuanced conversation about the treaty. I don't want to see a treaty being ratified if it will be gutting those core rights and values that is in the treaty and making a dangerous precedent not only for the U.S. domestic system, but internationally. Mm-hmm. We may better off keep this as a U.S. exceptional and international embarrassment, that the U.S. to always be shamed by that, and continue to work the incremental work that we're all doing, so that we then have we can benefit from both worlds. On one hand, we use the shaming and blaming because the U.S. is an embarrassment. At the same time, push the United States government on all levels, on all as much as we can, to make progress on issues of children's rights. And I think that is the real. I always have that conversation with a lot of colleagues that I value. They want to push the CEDAW, they want to push the CRC, the Disability Rights Convention, and I was, very, very much worry about what we end up with if that goes to the Senate. The White House didn't even send the CRC. The Convention on Rights of the Child is still in the White House, has not even been sent to the Senate. And then, yes, there is a need for the call on the administration to finish the review and to do it. But at the same time, let's just not be rushing it to the point where we will be shooting ourselves in the foot. Right. And we will be in that point. So I really want us to be, yes, using that exceptionalism for the purposes of moving a lot of things domestically, so that really it will be benefiting not just people here in the United States, but outside the United States, because that ultimately will impact U.S. foreign policy on human rights.
Eric, do you want to add?
I mean, this is an issue close to my heart as well. It killed me both of the times that the disability treaty went up, and CEDAW as well, to hear the Justice Department officials bending over backwards saying, this will not change American law at all. We are already fully in compliance with this. If I'm working for an organization that's working with homeless people on the streets who have a lot of more important things to be doing, how am I supposed to motivate them to get behind this treaty if it's not going to change, if we're in compliance already and it's, our human rights are guaranteed? I mean, it infuriates me. So, I can't get behind the ratify it and then be able to use it later movement, because because it is shooting ourselves in the foot, and so I have those conversations with a lot of people who are doing very good work and very passionate, and I appreciate that, but I think we're giving up too much.
This is really interesting. Do we have time for questions? We have 5 minutes. Okay, so I'm going to open it up. Okay, Kate, why don't we take 2 questions? So Katie, and then.
So just building on that last question, now that the U.S. is alone, I think there's at least a reasonable argument that the Convention on the Rights of the Child amounts to customary international law, right? So you don't even need to necessarily. I mean, it seems to me like you can have your cake and eat it too, right? That you can still be saying we're not meeting these standards, and also they're at least persuasive, if not in some sense binding under international law in the U.S. So do you find that there are ways to do that where you're navigating how you use a certain treaty or how you use a certain part of international law in your advocacy?
And wait, let's take this other question.
So mine is also related to the last point. I'd be curious to hear a little bit more about what you see the processes for making treaties more effective as U.S. lawyers. So, there's a lot of empirical data out there that shows that sort of countries that are promiscuous treaty signers are also very non-compliant with those treaties. So it's not only in the United States that we see signing and then gutting.
And so I'm wondering what sorts of procedures we could take, like if the process is to essentially create compliance and then ratify, or if there's some other way to engage with treaties to make them more meaningful, not only in the United States, but internationally, knowing that the U.S. isn't the only country where this vetting is sort of happening.
All right, wait, oh, all right, let me take these two, and then Joanne, and then Katrina, and then maybe we'll just go down the line.
So maybe getting at a different element of a similar theme, we also see, I think, on the state and local level, now local governments, the most recent being Miami-Dade County, passing CEDAW ordinances, not resolutions that are aspirational, but actually laws that recognize international treaties, and there's momentum in other places too. So I'm wondering if you can speak to a little bit, absent ratification, and in addition to thinking about those strategies, what are the opportunities at the state and local level beyond the awareness raising initiatives and technology?
Okay, Katrina, you really had the last question. And then we'll
This is picking up on themes that Ejim and Jamil raised around accountability that human rights lawyers have towards social movements. Beyond, ensuring that people who are most directly affected are speaking, and driving it, what are the ways that you feel like there are tensions between what the goals of the movement are and what is actually possible to achieve? And how do you reconcile that? What's the sort of balance that you go through as lawyers? And Eric, you might want to pipe in too, just because you've been working on this one issue for so long. And it'd just be interesting to hear like how your tactical and your approach and your strategies are accountable to that, but also pushing and also maybe not getting always what people want.
Let's go down the line, because I'm going to start with Melissa, because I think you've been last so many times.
Okay, sure. I think that I would maybe address the Megan question in terms of, thinking about how, if we're not going to be ratifying treaties, or if that's not as helpful, what other things we can think about. And actually, at the hearing for the Mandela Rules at the ACLU and other organizations put together recently, Malcolm Evans was talking about this and mentioned that, in the US, because of exceptionalism, often the best strategy is to just take the core principles and try to push those. And don't even name them as part of international human rights law, but just say, the US needs to create a strategy for taking care of the best interest of the child, or the US needs to create a strategy for investigating torture in these circumstances. And then we were specifically talking about a national preventive mechanism in prisons, and he was saying, we'll never have that in the US, but we can create something else that will look just like it, and maybe someday we can get there. We will never call it an NPM, but we might have something like that. So we just have to work around this weird US personality quirk, like you have, a weird uncle. It's like, we'll just, come at it from this other direction.
Yeah, on the
Weird Uncle Sam.
I agree. It's for the opportunities in the state, I think they're great. We have internal conversations where if there are federal claims to be brought, we almost think like if we want to raise our human rights arguments, keep those out and keep only the state claims, because we think there's more opportunity to be successful with where the state is. So in a particular case, we kept the federal claims out, we kept the state claims. It went up to the Court of Special Appeals. We actually lost on the substance of the case, but what the court said to us was, yes, Maryland courts have been looking at human rights law. We will continue to do so, and we're totally comfortable doing that, and we made a very direct and strong argument to say, okay, even though there's these, what is it called, the thing that says that you're non-executing clause. So even though there's that, we use the executive order to say, we still think these treaties apply to the state, and Maryland has a treaty clause which is unique to Maryland and some other jurisdictions. So we sort of use that to say, what's in these treaties does directly apply to Maryland, and the court said, Yeah, but in this case, we don't find it convincing enough, but we think human rights law can be used here. So, I mean, I think, you know, it's interesting because I think there's much more opportunity on the state level. You have a greater knowledge base of all the examples that are happening, but, you know, a lot of times it just happens. Maryland is very progressive. We now have a Republican governor, but still, in, you know, the past, all of these, the marriage equality and all these laws that are passed, they're never called human rights laws, but there's so much work that happens and it's just not called that. So that's just the interesting, like, you always have to do the work around, but I think there's a lot of space to do it.
Yeah, I think, you know, whether it's, and we, for the most part, we are not directly enforcing human rights treaties in federal courts, so whether you call it customary international law or treaty, you know, if you can get the point in substantively, then it's good enough. And like I said, I think looking beyond just getting that language, but how can you use these strategies to get other levers to push, like a Department of Justice statement of interest brief, you know, you can have a greater effect if you think beyond that box. In terms of implementation strategies, I think you know, where we have been, we've been moving in the right direction. And as I said before, it's really looking at what the government is giving us in terms of opportunities and then moving beyond that. It's, you know, dozens, it's not pretty, it's not, you know, rocket science, it's just meetings, phone calls, emails with federal officials, state, local officials, whoever it might be, and reinforcing that, you know, these are the things we should be doing because it's bad policy, because it's, you know, against a recommendation we got from the international level, and so continuing to build that. And in terms of accountability, you know, we do have tensions in terms of an incrementalist approach versus a, you know, and wanting to work with the federal government, and we have some allies who, you know, say what we've done isn't good enough yet, but they're excited about what we got done now, and it's, I think it's a recognition of the different roles that different organizations can play in a larger movement, and some can work within government and some need to always be hammering at the outside, and how can you work best together for that end goal, and accepting that, you know, you have those different roles to play.
Thanks. All right. You guys maybe take like a minute or two because we're going over.
Yeah, I'll do it in a minute.
Yeah.
So the question about the issue of compliance, I agree with you. There's an interesting data that's coming out as to, and that's something as actually the U.S. government always says to us that, well, you don't want us to, we take a different approach. We take the approach of when we sign and ratify, we want to be serious about our legal obligations. That's why it's different than other countries that are just not taking seriously those obligations. But that said, then you get that also other very, you know, strange argument that we're already in compliance with the convention, you know, on the elimination of all forms of racial discrimination, which is absurd. But the other thing that I want us to look outside the box and look how the United States complies with non-human rights treaties. Yes. And what are the lessons learned from that? You know, whether it's a trade and commercial activity. You know, there was a big controversy around the Child Custody Convention, the Hague Convention, that, you know, some states pushed back. The federal government and even members of Congress were like, you know, going after those states. No, we got to do this because we need this for our own interest. The same with, you know, other mechanisms, like, you know, take, for example, all these environmental treaties and environmental conversations about compliance with standards, international standards, you know, impact assessment, the Keystone pipeline, you know, how that had impacted the change of that. So I think that we need to be offline. One last thing I want to say about the Mandela rules that was mentioned. The ACLU and I personally was involved in the revision and updating the Mandela rules, the historic, you know, phenomenal process and phenomenal document. What we have, when we started, we said we as ACLU, we want to more focus on the United States government engagement in this process, and we want to take up a couple of issues that are addressed in the revisions, but also contribute generally on the revisions. And we took issue of solitary confinement because we felt that that's something that would speak a lot to the people who are working hard on this issue. And the way that we started, we saw that the State Department people who were going to Vienna, were going to these intergovernmental expert meetings, we're pushing back and we were trying to water down some of those important revisions that were put forward based on international development that happened since 1955. And I think by really engaging them and offering the different kinds of value added, the benefits of, and not seeing it as, oh, you just, at some point in the room, the United States was agreeing with Iran on some of pushbacks against revisions that were coming from Austria, Vienna, Switzerland, Sweden, Norway, and other countries. And yet, because of the way that the issue also evolved domestically, had an impact on how the United States delegation behaved internationally. The conversation all of a sudden also shifted in the United States, so the delegation was easier for the delegation to agree on some of those revisions. But at the same time, we had devised a strategy of talking to Justice Department partners, not just to the State Department partners. State Department lawyers sometimes are the ones who are, you're standing and trying to really push back and trying to water down and try to the text, but also to be the lawyers of the US government, but sometimes they don't really know what are the real domestic applicable standards and what is happening under the US domestic laws. So you really need to bring back to Carrie's tips, you really need to engage with the different partners, and having Justice Department know about the Mandela rules, know about the significance of what they do as part of the Civil Rights Division, suing states on solitary confinement issues, on prisoners' issues, had a really great impact on a way that we were able to shift around the way that the US government has engaged, and now it is championing the Mandela rules and has really great things to offer, even if they are not legally binding rules, but as a matter of international standards that are really put the minimum standards for the treatment of prisoners.
All right, Ejim, you have the last word.
Okay. So let me just say, because everyone has said it, I agree with what everyone's saying on standards and emphasizing standards, substance, principles more than ratification. But I also want to make a pitch, and I think people here, everyone agrees with me up here, that we should not give up on pushing for human rights language as well and insisting whenever we can, because I think by not doing so, we might inadvertently also play into US exceptionalism. On the question regarding the tensions, I think there's a reason that, Reena mentioned earlier about how sometimes talking about human rights law brings up the response, oh, does that mean you don't support Black Lives Matter? But I think there's a reason that comes up. I think it comes up because a lot of times, what I was speaking to earlier, human rights, when we're doing human rights work, there has been reluctance, if you will, and that might be too strong a word, but hesitancy, I should say, to talk about Black lives prior to just what happened with the movement a year ago. So, and there's been evidence other places that when you talk about human rights, that's been used to, other people have at least viewed it as being used not to talk about specific issues that relate to women, like I know this came up in the UK, or domestically, what's specifically happening to people of African descent. So I would say I don't have an answer, really, except to say that sometimes when you hear something that's crazy, don't, don't blow it, don't dismiss it. I remember a guy who used to tell me that the New York City foster care system was created to channel Black and brown children from the cradle to the prison system. And I would nod and say, yes, that's true, but I thought he was a little bit, could use some help. And until I started learning more about the New York City foster care system, and child welfare system, I should say more broadly, and learned his story about how his child had been taken away from him for absolutely no reason, except the fact that really he is a person of color who didn't have the means, that I realized, he may not be too far from the truth, because either by commission or a failure to act, the New York City administration had created this channel. So I would say it starts with making, beyond having people come up and speak and tell their story, right? It's really listening and making sure that what we hear is what drives our advocacy.
Thanks so much. So will everyone just join me in thanking this panel? And
creative, and I thought amusingly extreme, that people would find that extreme. I thought was amusing, but they did. And it was the simple idea that human rights matter in the United States, that they matter within and on our borders. And, you know, we came together and we had to ask ourselves, what do we have on our side? Did we have the government? No, we still don't. We have the occasional plant these days, but we don't really have the government on our side. Did we have the press? Well, Jamil's already explained it's not going to make us a media star to continue down this path. And, you know, did we have the law? I mean, this isn't, even though this was a legal project, did we have the law? No, actually, we still don't. We have enormous resistance. On the contrary, as Cindy noted, laws have actually shrunk in the arena of rights in the last 17 years. But still, these 17 fools, and I count myself among them, came together not only to stake our reputations, because frankly, what's that? But to stake something more meaningful. To stake, in fact, to risk all of our energy, all of our sense of doing something meaningful. That was what was at stake. We staked our sense of doing something meaningful on this path, nonetheless, despite the fact that we had very little on our side. And from what I've heard today, we haven't finished. We haven't won this battle of ideas, but we have won a lot, right? Almost every one of our projects was crazy and still is crazy. When I heard Carrie was going to go to the Inter-American Commission on Human Rights to challenge the United States government on domestic violence, well, you can imagine what I thought, right? Because I was a real human rights aficionado. So I thought, why is she doing that? That's never going to work. I tell her that. I said, go Carrie. But I was really wondering, is this going to work? And it did. It did because she was creative and persistent. We need creative extremists, but we need persistent ones as well. It worked because she had Jessica standing there with her. She wasn't doing it for Jessica. She was doing it with Jessica. So you can imagine these two women on the steps there, Jessica having suffered one of the most horrific and almost, you can't find the words for the kind of violence where a person you love kills your children, right? These are things that are beyond our human imagination. And she's standing there relying on Carrie, and Carrie standing there promising her on the steps that this is going to make a difference, that this suffering wouldn't have been in vain. And yet she had no idea how that was going to be the case, but she plowed forward, and that takes courage. That takes a leap of faith. If you're going to do something beyond where we are today, and we're not in a good place, you need to take that leap of faith, which is one of the things I think Ejim was kind of referring to implicitly, to listen to what people are suffering and take that leap of faith. And that's why we take up these projects. We play a long game because the short games are not getting us anywhere. When Eric thought, I thought he was nuts. I said, when Eric thought, oh, we're going to get all these international committees and experts, and that's going to make HUD do something. I thought, oh, good luck to you. And it's taken 10 years, and I am grateful to say I was so wrong. I was so wrong to doubt that. But he took a leap of faith because he thought it was important. And he pushed his organization to take that leap of faith because he was talking to people. He works with a volunteer at my organization who spent 3 years on the streets of Miami, who was homeless, and who was politically transformed by that experience. And I can tell you, ever since this new ruling has been, this new decision has been announced, that man has not stopped smiling. And you had each other. You had Rob yelling at you, always telling you you weren't doing enough, because he's like that. And he had you on the inside. So it's a partnership, right? The concept of bringing human rights home is not just about the law. It's about actually humanizing the law as well. It's about changing not only the law, but changing ourselves. And that's the kind of work you heard from Jamil. And you heard about Maryland Legal Services, which I remember when Peter started that work years ago. It's about changing ourselves to be a different community, to have different kinds of institutions. My first job was at the ACLU, and it's not the same ACLU that it was today. It really wasn't. I don't ever remember hearing the ACLU talk about workers the way you talk about workers today, or even talk about people. My client was the Constitution. And today the ACLU, with its contradictory libertarian and progressive history, has reconnected with communities. And part of that has been the kind of leadership Jamil and Chandra and others have brought to that institution to make it a full partner in the progressive community. And similarly, legal services wasn't about services when it started. Legal service lawyers back in the 70s were freedom fighters. They weren't getting people housing, they were fighting for human liberation. And the Reagan administration cut them down because they were afraid of them. Because they knew when people's lawyers were on the street with people, that was scary. That was scary to the elites. And we are in a moment where elites have become quite dangerous. So it is exciting to know that that human rights conversation at Legal Services, reviving that history and bringing those lawyers back into the community fighting for human liberation, because we can stop short of nothing less. And when you're in law school, it's hard to remember that, which is why it's so important that these projects exist, this Bringing Human Rights Home project exists, because it's not just, it's about changing the world, but in order to change the world, we have to change ourselves. It's about playing that long game and having that faith that even your closest colleagues would say, I don't know if that's going to work. And you say, yeah, it is. It has to. It has to, because we have the inexplicable assumption that if you lose your house, you're somehow a criminal. If you lose your house and you have nowhere to go, if you make sleeping in the street a crime, you are saying that by losing your house, you're a criminal. That's pathological. And we're living in pathological times. To challenge that assumption, we have to, by all means available to us. And that's what Eric did for a decade. It took a long time. But really, the important question today, I forgot the one that I'll never forget this experience, but I forgot what I wanted to say about the network. I was sitting in front of the other network, the U.S. Human Rights Network. I call it the Lawyers Network and then the network. That's my shorthand. But I was sitting in front of my computer one day, as I do most days, because that's what I do. I sit in front of my computer. And something comes across my email, and I click. And I was speechless, which, if anyone knows me, is a rare moment. All of a sudden, and I have to admit, I'll confess, I hate when I have to go to the UN. People talk about being concerned about torture, and I want to kill them. Right? You're concerned. You're not outraged. You're not horrified. You don't want to go do something. But it's a very kind of muted environment when you're in the UN, the sort of hollowed halls of the UN. And here we were at a treaty. Here they were, not me. I was watching this on my computer, at a treaty review. And it was all that hollowed hall stuff. You could see it in the picture, right? It was that place I'd been to so many times. But instead of what I was used to seeing, which is a lot of men and women in suits, nodding and taking notes on their computers and with their pens, there were a semicircle of black leaders after the killing of Mike Brown, standing up, not sitting down to hear about how black people are killed, standing up next to each other, holding their hands up, silently, but utterly disruptive. And that is the modeling we must learn from. We must be utterly disruptive in those spaces, because it is our job to disrupt injustice. And that is what you have to remind yourself every day when you're being taught about a system that is actually a system of injustice, and it's being legitimated in institutions like this. Not even consciously, but you cannot forget as you're being educated that you need to diseducate yourself simultaneously every single day, because what you are being trained in is a system of injustice. And what you came here to do is create a system of justice. And what this project is about, embedded in this very place that teaches you about a system of injustice, is challenging that from within. And all these people sitting here have dedicated now more than a decade and a half, many of them, several of them more than that, to that project. So never forget what you're doing. Sometimes what you're doing is as a mechanic, as Carrie said, as a critic, as a behind-the-scenes negotiator. It doesn't, you forget. what it's about, but it's about a much larger project. And the real question today, for at least for all of us, I'm sure, is not so much what we're going to do next, but what you're going to do next. Because while we all thought we were being all original and stuff, when we started this network, over time we learned that in fact this struggle has been a long one. One could even call it an ancient struggle. It's been at least centuries old. And people have been fighting in different spaces with all our tools and vehicles for human rights for a long time. And for the students in the room, if you don't pick up that baton and win this relay race, then all this decades of work would really be for nothing. So you cannot imagine how critical it is that you quickly get up to speed on this political project, which is in fact a transformative one, and one that we desperately need, and that one that we enter as lawyers, but we're working with communities. The way you worked with Rob and you with Jessica, the way you brought the parents of many of the people, not just one family, but many families of those killed in the streets. And when you work closely with those in solitary confinement, the families of those, and the advocates working with them, we're working with them. We're there to support them. But it is our responsibility, as at least at this stage in our life, privileged allies, to use every vehicle, every space, every opportunity to move that forward. So that's it. And now we're done.